Hello friends, this is the second episode of Nyay Patsala. Today's topic is on public interest litigation, which in short is referred as PIL. Let us look into some of the leading cases on PIL where the Supreme Courts have dealt with various issues. The first reported case of PIL was of the year of 1979, which focused on the inhuman conditions of prisons and undertrial prisoners. In Hussainara Khatoon versus State of Bihar, reported in 1981 SCC page 19, a PIL was filed by an advocate on the basis of the news item published in the Indian Express, which highlighted the plight of thousands of undertrial prisoners languishing in various jails of Bihar. Interestingly, this proceeding led to the release of more than 40,000 undertrial prisoners. In this case, the right to speedy justice emerged as a basic fundamental right which had been denied to these prisoners. The concept of PIL was first broadcast in India by Justice Krishna in 1976, and that was the case of Mumbai Kamgar Sabha versus Abdul Thai, reported in AIR 1976 SC 1455. A new era of the PIL movement was heralded by Justice P.N. Bhagavati in the case of S.P. Gupta versus Union of India, reported in 1981 Supply SCC page 81. And we commonly refer to it as the first judge's case. Of course, it was partly overruled in the second judge's case, which we refer as the Supreme Court Advocates on Record Association versus Union of India. But the first judge's case was the case where the Supreme Court articulated the concept of PIL. In this case, it was held that any member of the public or social action group acting bona fide can invoke the writ jurisdiction of the High Court or the Supreme Court, seeking redressal against violation of a legal or constitutional rights of persons who due to social or economic or any other disability cannot approach the court. In the case of Anil Yadav versus State of Bihar, which was reported in 1982 2 SCC 195. In this case, the Supreme Court signaled the growth of social activism and investigative litigation. In this case, it exposed the brutalities of the police. A newspaper report revealed that about 33 suspected criminals were blinded by the police in Bihar by putting acid into their eyes. By various interim orders, the Supreme Court directed the state government to bring the blinded man to Delhi for medical treatment. And in this case, it also ordered for speedy prosecution of the guilty policeman. The court also highlighted the right to free legal aid as a fundamental right of every accused. In the case of Bandhu Mukti Morcha versus Union of India, which was reported in 1984 3 SCC 161, a public spirited organization on behalf of persons belonging to socially and economic weaker section complained before the Supreme Court regarding violation of the human rights on being forced to serve as bonded laborers. Although the bonded laborers did not come directly before the court due to various economic constraint, the Supreme Court in this case has held that this petition filed by the public spirited organization on behalf of the bonded laborers are maintainable. In the case of Citizen for Democracy versus State of Assam, reported in 1995 3 SCC 743, the Supreme Court declared that the handcuffs and other fetters shall not be forced upon a prisoner while lodged in jail or while in transport or transmit from one jail to another or to the court or back. Because if you handcuff a person in court, it's a very humiliating experience, and this is one of the cases where the Supreme Court has held that the handcuffs should not be forced upon a prisoner. In the case of People's Union for Democratic Rights versus Union of India, In this case, the Supreme Court dealt with two issues. First, whether the writ petition is maintainable against a private individual under Article 32 of the Constitution of India, and whether Article 21 of the Constitution of India also include right to live with human dignity and right to livelihood. In this case, the Supreme Court held and recognized that a third party could directly petition, whether through a letter or other means, and seek the intervention of the court in a matter where another party's fundamental rights were being violated. In this case, adverting to the constitutional prohibition on beggar or forced labor and traffic in human beings, the PDR organization submitted that workers contracted to build the large sports complex at the Asian Games villages in Delhi were being exploited. And PDR asked the court to recognize that the beggars was far more compelling than compelling someone to work against his or her will. And under this exploitative and humiliating condition, they were not even compensated by paying them the minimum wages, which was violative of the fundamental rights. In the case of Indian Bank Association, Bombay and others versus Devkala Consultancy Services and other, this is again another famous case of the Supreme Court, where the Supreme Court has held that in an appropriate case, even if the petitioner may have moved the court in a private interest, but for furtherance of public interest, it is sometimes necessary to inquire into the state of affairs of the subject of litigation in the interest of justice. In this case, the Supreme Court held that a private interest case can also be treated as public interest case. Normally, a PIL file can't be withdrawn. If some person tries to withdraw the PIL, the court appoints an amicus curiae, or the court may take the PIL to its logical ends. In Guruvayu Deviation Managing Committee versus C.K. Rajan and others, which was reported in 2003 7 SCC 546, in this case, the Supreme Court laid down certain guidelines in regard to PIL. We must be very familiar with the name Mr. M.C. Mehta, who is a well-known environmentalist of India, who has filed various PILs in the Supreme Court and sought the intervention of the courts. One of the celebrated case was in regard to manufacture and sale of hazardous product, because after the Bhopal gas tragedy case, the MC Mehta moved the Supreme Court that these industries, some principles and norms for determining the liabilities of these large enterprises who are engaged in manufacture and sale of hazardous products has to be discussed, and some prohibition has to be made. Mr. M.C. Mehta has also approached the Honorable Supreme Court in the case of banning tanning, which was being carried near the Kanpur on the banks of the river Ganga. In this public interest litigation, the petitioner highlighted the public nuisance caused by the serious pollution of the river Ganga and for protecting the lives of the people using Ganga water. The Supreme Court held that the petitioner, although not a riparian owner, is entitled to move the court for the enforcement of statutory provision, as he is the person interested in protecting the lives of the people who make use of Ganga water. In the case of Paramanda Qatar versus Union of India, reported in 1989 4 SCC 286, the Supreme Court has held that a public interest litigation filed by human rights activists fighting for general public interest in regard to the medical profession to give medical aid to every injured citizen was highlighted. Because normally what happen in accident cases earlier, they have to wait for the police report and all, the doctor will not examine the injured person. Now, in view of the directions given in this case, even a private doctor has to examine an accident case in emergency, and without waiting for any police report or police investigation, if an injured person is brought to the hospital, he should be given immediate medical aid. There are various cases of the Supreme Court where direction have been passed based on the PIL filed before the court. In the case of Council for Environmental Legal Action versus Union of India, which was reported in 1996 3 SCC page 212, The Supreme Court had issued orders and direction for enforcing the laws to protect ecology. Likewise, in Bihar Legal Service Society was the Chief Justice of India. The Supreme Court made it clear that the strategy of public interest litigation has been evolved by the Supreme Court with a view to bring justice within the easy reach of the poor and the disadvantaged sections of the society. The Honorable Supreme Court, while taking note of the instances of misuse of PIL in Ashok Kumar Pandey versus State of West Bengal, reported in 1989 1 SCC, has observed that public interest litigation, which has now come to occupy an important field in the administration of law, should not be publicity interest litigation or private interest litigation or politic interest litigation or the latest trend paisa income litigation. If PIL is not properly regulated and abuse averted, sometimes it becomes a tool in unscrupulous hands to release vendetta and wreak vengeance as well. In all PIL, there must be real public interest involved and not like poking one's nose into every probe. Instead of Uttaranchal versus Balwant Singh Shofal and others, reported in 2014 8 SCC 47C, the Supreme Court has entertained this PIL in order to preserve the purity and sanctity of the PIL. In this case, the Supreme Court has laid down several guidelines to be followed by courts while deciding a PIL. One of the direction was that the court must encourage genuine and bona fide PIL and effectively discourage and curb the PIL for extraneous consideration. And the court should prima facie verify the credentials of the petitioner before entertaining a PIL. The court should be prima facie satisfied regarding the correctness of the contents of the petition before entertaining a PIL. These are some of the guidelines which was framed in this case. In the case of Unikrishnan versus State of Andhra Pradesh, which was reported in 1993 1 SCC 645, this was a case where the Supreme Court was deciding the issue of privatization of education as well as capitation fees charged by this institution. In that case, the Supreme Court has held that the following are the rights which are covered under Article 21. Number 1, the right to go abroad. Number 2, the right to privacy. Number 3, the right against solitary confinement, which was again decided in Sunil Bhatra versus the Delhi administration case reported in 1978 4 SCC 494. The right against bar fetters, the right to legal aid, the right to speedy trial, the right against handcuffing, the right against delayed execution, the right against custodial violence, the right against public hanging, doctor's assistance, shelters. These are some of the issues where the Supreme Court has held is covered under Article 21 of the Constitution of India. Public interest litigation has given a voice to millions of marginalized people of society, women and children. Public interest litigation is one of the most important contributions to Indian jurisprudence. It is an instrument of social change. It has worked for the welfare of every section of the society. It is the sword of everyone used for taking justice. And this is an innovation of the Indian judiciary which has proved beneficial for the developing country like India. PIL has been used as a strategy to combat the atrocities prevailing in the society. It's an institutional initiative towards the welfare of the needy class of the society. Yes, some persons have misused the PIL, but that is negligible. The courts are conscious enough to deal with such type of person who files frivolous and vexatious PIL before the High Court or the Supreme Court of India. Government sometimes tries to discourage the PIL jurisdiction of the courts by saying that the Lakshman Rekha in case of separation of power between the executive and the judiciary should not be crossed. Those instances are very rare. The Supreme Court of India, in various cases which I have referred earlier, has paved the way for many beneficial legislation in India. Say for example in Vishaka case, prior to it there was no guidelines how to deal with sexual harassment of women in workplace. Now as a lawyer who like me, who has practiced in the High Court for around 30 years, I started my practice in many of the PILs at that filed before the High Court in the Guwahati High Court. Some of the PILs which I have filed in the Guwahati High Court through my junior advocate is I had forced the government to draft a legislation on witch hunting. I have forced the government to make the ropeway which was abandoned by the government of Assam. I had forced the government to make public toilets under the flyovers. I have forced the government to see that the right of hawking zones in the city of Guwahati are earmarked. During my entire life as a lawyer, I am always at the forefront while public interest litigations issues has to be filed. I have been appointed as amicus curiae in some of the PILs of the Guwahati High Court which are still pending adjudication. PIL may not be so remunerative to a lawyer to start his practice, but as a senior counsel, now it is my payback time to the society or to the legal field for what I am today. So this public interest litigation was a subject which was very close to me, and I have shared my ideas and views with my followers or with my junior members of the bar, so that they can understand or they can realize that how powerful tool this is in the hands of a lawyer to espouse the cause of the people, downtrodden people of the society, or to take up the shackles against the government for their misdeeds or for indulging in any corruption in execution of projects for the development of the state. My advice to the young members at the bar, that whenever you have to file a PIL, proper research work has to be done. You don't just take a newspaper report and file and annex it to a petition and file a PIL. You go to the spot, do the verification, do your homework and research. Then I am sure the court will appreciate your hard work before filing the PIL. If a petitioner comes to for filing a PIL, first look into the credentials of that petitioner, whether he is motivated by any political consideration or it is in respect of some private interest. Now in some PIL you will also find that there are some RTI activists who misuse the weapon of PIL. You need to be careful against those persons. PIL works are mostly pro bono, but it gives an opportunity to pay back to the society for what you are today. The High Court also sometimes suo moto takes cognizance of certain reports and register a PIL. But as a junior counsel, you should always take up issues which affect the marginalized people of the society who cannot come to the court directly. There are so many issues where our hearts burns to see the plight of those people of the society. They are at a disadvantageous position. So as a lawyer, we should highlight those grievances before the court, and I am sure the court will take appropriate measures to address those grievances. Nyay Pathshala is a channel dedicated for free legal education and empowerment. We will continue uploading many such informative videos on law so that it helps the young members of at the bar as well as anyone who is interested in the subject of law. Therefore, once again, I offer my thanks to all the people who have taken time to listen to our channel and gave their thumbs up for the work that we have undertaken.